The practical implementation of the provisions on the competence to settle parents and child identification, Part 1. Rights on parents and child identification is one of the moral rights in the relationship of marriage and family, which, inherent to each natural person, cannot be transferred to other persons and are protected by law. It's important to determine the parents and child because it leads to a lot of legal issues such as custody, support, inheritance. In fact, the identification of parents and children is not only a common trait during the marriage period, but also a common trait between people who are not in the marriage. At last time, the procedure must be carried out at the competent authority under the law provisions. Implementing this provision, not only the persons requesting, but also the competent authorities are confused about the competence to settle the parents and child identification. We build on this analysis to identify the practical implementation of the procedures on the competence to settle the parents and child identification through our practical legal support activities. Therefore, we can see then the legal issues related to the competence, the capacity in participating in the procedures when settling the request of parents and child identification. 1. Vietnamese current law provisions on the competence to settle parents and child identification. According to Article 101, Law on Marriage and Family, 2014, there are two government authorities competent to settle identification of parents and children. Firstly, a Civil Status Registration Department, which is commune-level people's committees of places of residence of recognizing or recognized parents or children shall register parents and child at recognition. Secondly, competent court settles the identification of parents and children in the following cases. There are disputes. The person requesting for being identified as parents or child has died. When a person who requests identification of his or her parents or child dies, his or her next of kin has the right to request a court to identify the parents or child for him or her. A person who is not recognized as the parents of a person may request a court to identify that the latter is his or her child. On the other hand, it is stipulated in Article 28 and Article 29 of Civil Procedure Code 2015 on the disputes falling under the court's jurisdiction as follows. Disputes over determination of fathers or mothers for children or determination of children for fathers or mothers is one of the marriage and family-related disputes falling under the court's jurisdiction, and the petition for determination of fathers or mothers for children or determination of children for fathers or mothers according to legislation on marriage and family is one of the marriage and family-related petitions falling under the court's jurisdiction, and the petition for determination of fathers or mothers for children or determination of children for fathers or mothers according to legislation on marriage and family is one of the marriage and family-related petitions falling under the court's jurisdiction. Currently, under the Article 16 of the Circular No. 04/2020 TT-BTP dated May 28, 2020 of Ministry of Justice on elaborating a number of articles of law on civil status and Government Decree No. 123/2015 NDCP dated November 15, 2015 on guidelines for law on civil status taking effect from July 16, 2020, Parents-Child Relationship Recognition and Civil Status Revision in some special cases as follows. People's courts shall decide cases where the wife gives birth or is pregnant during the marriage period, but the wife or husband doesn't recognize the child as their common child or another person wishes to recognize the child as their own as per the law. If the People's Court rejects such a case, the civil registration authority shall receive and handle the application for registration of the birth of the child with unknown father or application for father-child relationship recognition, which shall include a written rejection from the court and proof of the father-child relationship mentioned in Clause 1, Article 14 of the circular. Thus, there is no more falling under the court's jurisdiction. The wife gives birth or is pregnant during the marriage period, but the wife or husband does not recognize the child as their common child, or another person wishes to recognize the child. However, the decision for the case can be transferred to the civil status registration agencies if the court rejects this. 2. Some legal questions court related to the competence to settle parents and child identification. 1. What is the dispute related to the parents and child identification? Until now, there is no regulation on the definition of disputes related to the parents and child identification, which leads to the confusion of the courts and civil status agencies about the competence to settle when being requested. To understand more about the confusing competence to settle these cases, we will analyze the practical case. Due to unhappy common life, Miss Phan Thị Thanh Thi and her husband, Mr. LUheden from 2010 have been living separately. Then Miss T and Mr. V.I have a relationship. They have a common child who was born at Hải Phòng Maternity Hospital on June 9, 2014. His name is V.I PH, whereby Miss T and her husband have not divorced. Mr. TH and Miss T have come to the Commune-level People's Committee, where Miss T resides several times to apply for their child's birth certificate, whose family name is passed from Mr. TH. However, their application was rejected, and they were advised by the civil status officers to file a lawsuit at a competent court because there was a dispute arising from the case. Not understanding the law provisions and avoiding filing a lawsuit, they agreed that there was no dispute between them. It was determined that PH is a common child, and Mr. H had no opinion. In February 2020, Mr. V.I filed a lawsuit to the court to settle this issue so that he could apply for his child's admission at school. On March 3, 2020, People's Court in HA District, Hải Phòng City accepted the case, which was dispute on father identification, in which the status of the involved parties was determined as follows: plaintiff, Mr. V.I defendant, Ms. Phan Thị Thanh Thi. The persons with related interest and obligations, Mr. LUheden, considering the case of Mr. V.I and Ms. Phan Thị Thanh Thi, the People's Court of HA District, Hải Phòng City determined that Mr. TH was the plaintiff and Ms. T was the defendant. Compared to the Article 68 of Civil Procedure Code 2015, the involved parties in civil lawsuits are agencies, organizations, and individuals, including the plaintiffs, the defendants, and the person with related interest and obligations, in which the plaintiff in a civil lawsuit is the person that initiates lawsuit, or the person for whom the other agencies, organizations, and individuals prescribed by this code initiates the lawsuit to request the court to resolve the civil lawsuit when he or she holds that the legitimate rights and interests of that person have been infringed upon. The defendant in the civil lawsuit is the person against whom the plaintiff initiates a lawsuit, or the other agencies, organizations, and individuals prescribed by this code initiates a lawsuit to request the court to resolve the civil lawsuit when they hold that the legitimate rights and interests of the plaintiff have been infringed upon by such person. That too we can understand from the determination of the People's Court in HA District. Hải Phòng CD about the status of the involved parties compared to the spirit of Article 68 of Civil Procedure Code 2015 was as follows. Mr. V.I Lê Nin files a lawsuit to ask the court to protect his legitimate rights and interests, as he holds that his rights and interests have been infringed by Mr. T. However, in reality, Mr. Th did not want to file this case, as his rights and interests were not infringed by Mr. T. Mr. agreed that PH is the common trial. The question called is that what the combatants did not consider. Mr. Văn H., Mr.'s husband, as the defendant while their arm was to determine the father of the child. The situation caused the issue that is it necessary to define the dispute in order to determine the competence to settle, ensure consistency in the legal documents, avoid the inaccuracy and confusion caused by the unclear determination of the status of the involved parties, and establishment of the legal relationship between the parties when putting the law provisions into practice. Civil status. Civil status means being single, married, separated, divorced in a civil partnership, or being a formal civil partner in a civil partnership that has ended by death or being dissolved. Birth certificate, a document recording a baby's birth, including such information as name, time, place, and parents. Marriage certificate, the document that shows two people are legally married. Native place, the town or city or area that a person is from, especially the one in which they were born and lived while young. Guardian, a person who has the legal right and responsibility of taking care of someone who cannot take care of himself or herself, such as a child whose parents have died.